Yes, Mr. Patil.
Please, my lords. May I proceed, my lords?
Yes, yes.
My lord, the petitioner from Punjab.
So your original documents are not being returned, right?
Please, my lord. My original documents, my lord, are not being returned. In addition, the first year fees which I had paid, amounting to 7 lakhs and odd, my lord, is also not being returned. Now, what happened, my lord, was that there was a dispute insofar as the Christian Medical College, Jalandhar, is concerned, which was pending in the Punjab and Haryana High Court.
One issue, Mr. Patil.
Please, my lords.
It is a private medical college, right? Rajeshwari Medical
Yes,
College.
it is a private medical
Yes,
college.
yes, my lord.
It is a private.
You will have to tell us how a petition would like seeking refund.
Please, my lords. Insofar as that is concerned, my lord, the admission is done by the Karnataka Examinations Authority through the counselling conducted by the KEA, and the fees is paid to the. My lords.
This issue must have been adjudicated, right? Already.
My lords. In fact, in the Constitution Bench judgment in Islamic Academy case, and subsequently, my lord.
That's what we are.
Yes, there. The college, it's very clearly held by the Apex Court Constitution Bench, yes, that the fees, my lord, cannot be withheld by the college. Only in the event.
And rate petition would like to seek a refund.
Certainly, my lord. Certainly, my lord. As far as that is concerned.
You are ready on this aspect, right?
On that aspect, I am ready. On that aspect, I am ready. Islamic Academy's case is there. Because,
my lord, your lordship, kindly see the interim order dated 24/4/2019, my lord. 24/4/2019. He wanted the original documents, my lord. Admittedly, my lord, he has not joined the course, and we have lost, my lord, 3 years. What we are saying is that he himself has given up, my lord, refund of the document of 7,74,500.
Once I complete, my lord, learned counsel for the 6th respondent and 5th
respondent. No.
I have not yet completed.
Yeah, okay, but you said originals are not returned.
Originals have been returned, right?
Now by virtue of the interim order which has been granted on the 24th of April 2019,
so they have been returned.
They have been returned. They have been returned.
And he has given undertaking that he would not seek a refund of 7,74,500.
Yes, sir.
But he has to pay us 22 lakhs, my lord, towards tuition fees, which we have lost, my lord, for no good reason.
This is not your petition.
Well, my lord,
we cannot direct him to deposit you, pay you 50 lakhs, right?
No, the original documents, my lord, original documents would be withheld, provided, my lord, he would pay the entire fees.
I mean, it's really surprising that this is not family. You are not permitting Mr. Patil to argue.
I'm sorry.
If you are the petitioner, then
I'm sorry. Let him proceed, my lord.
We will hear Mr. Patil later on. You begin first. What is
I'm sorry, my lord.
Case? What is your
No, I only wanted to submit, my lord, that he has he has admitted not to seek a refund. That's all I wanted to submit, my lord. Let him proceed, my lord. I'm sorry. Let him proceed.
Yes. I have not appointment. We are going, but now I am in court. I will tell you that.
Yes.
May I submit, my lords? Insofar as the question of original documents are concerned, the division bench, my lord, by way of an interim order dated 24th of April 2019, since my admission in the postgraduate course in the Christian Medical College, Ludhiana, was being cancelled by Baba Farid University of Health Sciences. Therefore, I made an interim application for a direction that my original documents may be returned so that I can furnish it to the Baba Farid University and retain my admission which I have obtained there. So that particular prayer, my lord, regarding the refund of the original documents will no longer survive for consideration. The original documents have been returned. Now, what would remain, survive for consideration in this writ petition is whether I am entitled to this refund of the
Read that
first.
order 24th April.
Please, my lord. May I read it, my lord? We have heard learned counsel for the petitioner as well as learned counsel for the fifth respondent institution.
Come to second page.
My lord, second page, my lord.
By way of reply.
Yes, ma'am. By way of reply, learned counsel for the petitioner submits that the petitioner will not seek refund of 7,74,500, which is with the fifth respondent institution. He submits that the petitioner will not press prayer C. That was a submission, my lord, which I had made on that particular day.
That's the end of the matter.
Now, what has happened, my lord, is if the university, my lord, I mean the particular college, is insisting and demanding that I pay the balance fees also for the remaining 2 years. That was the submission which was made. That is why the petition was kept pending.
That prayer cannot be dealt with in this petition.
Yes, precisely.
Prayer of respondent. In your petition, we cannot direct you to pay 22 lakhs to respondent, right?
Exactly, my lord. But such a prayer was made.
No, they can say anything. He says,
yes, absolutely.
They say that president of this respondent number 5 institution be given a constitutional post. He can say like that.
Please, my lord.
The question is whether it should fall within the parameters of law. He can say anything. We can't deprive.
Certainly. But kindly see the last portion of that order, my lord.
Nothing survives practically.
No, one word is added there. It is further clarified that the interim order is subject to the result of the writ petition. Only for that, but if my lord were to clarify that since the documents have been returned and I am not pressing the other portion regarding prayer C.
Yes, that's what.
And therefore, my lord, the writ petition will be disposed of as having been become infructuous without disturbing, my lord, the order relating to return of documents.
Yes. Okay.
Because that should be safeguarded, my lord. If I am again, they hold out a case against me saying that you have to return the original documents or they pursue some other remedy against me, my entire admission before the Baba Farid University may be cancelled if I have to. But one other aspect, my lord, if my lords, before I conclude, just one sentence, if I may be permitted. Now, because of the pendency of the writ petition before the Punjab and Haryana High Court, my lord, in the month of May 2018, I participated in the counselling conducted by KEA on the 17th of May 2018. Now, on 21st of May 2018, Punjab and Haryana passed an order saying that.
Oh, how is it relevant?
Relevant here because, my lord, on 17th, my lord, when I participated in the counselling here in Karnataka, the order had not come. Therefore, my lord, I participated in the counselling here and took the seat and paid the fees to KEA, not to the college. I have not joined the college. That is what even the learned counsel for fifth respondent says. I participated in the counselling and the counselling specific, there it is stated, my lord, if before the last date was of 31st of May. So there was still 15 days. On 24th of May, I joined the Christian Medical College there in Ludhiana. And on 25th of May, I have communicated both to the college as well as to the DME that I am surrendering this seat. Now the college in turn on 25th has returned to the DME saying that the student has surrendered the seat. Therefore, kindly revert this seat to the college for filling it by the college at its own end. Do not offer it. Now, this is a lapse on the part. There was still 31st of May. 7 days were there. They have not filled up the college. Would it be fair on their part to retain this fees when I have not joined the course? That is the issue, my lord. That is why I am bringing up this. Though at that point of time, I have made this submission. If my lords were to, without disturbing the order regarding return of documents, but 7,74,000 is a huge sum. It is not as if, my lord, I have left this course midstream. Well before, within the last date, 1 week before the last date, my lord, I have surrendered the admission saying that I am unable to join or I don't want to join because I have obtained admission there. And one more round of counselling was in fact conducted by KEA on the 28th of May. 29th of May. 29th of May. I have produced that document also.
30th May you have written.
My lord. That is all my submission is that without disturbing the 24/4/2019 interim order, if the writ petition is disposed of, my lord, I would have no objections also. But I am still pressing this particular prayer for this reason. Because there was a judicial intervention regarding a stay granted by the Punjab and Haryana High Court, which was, by the Apex Court, which was not being complied with the direction issued by the Apex Court, was not being complied with the Christian Medical College. Punjab and Haryana High Court intervened and directed. Thereafter, they allowed admissions, Christian Medical College. Because of these circumstances, my lord, I was forced to participate in the counselling on 17th of May. All this has happened between 14th of May and the 21st of May. 14th of May, KE has issued the notification. 17th of May, they have conducted the counselling. 21st of May, Punjab and Haryana has passed the order. Now, my seat was stuck there. That is the only reason why I have participated. But I have not joined the course at all. Considering that fact, my lord, if my lordship were to consider my prayer for refund, even a partial amount of what I have paid to the college, my lord, I'll be
You have given up that prayer. You have given up that.
That point of time, my lord, because for me, return of my documents was more important. Because my admission there was being cancelled. Neither here nor there. Therefore, even I leave it at that. I leave it at that. I leave it at that.
Yes.
My lord,
Yes.
may I submit, my lord?
Yes, please.
My lord, I have got two submissions to make, my lord. If the originals are, my lord, are returned, our right to collect, my lord, fees for all the 3 years, my lord, would be frustrated and defeated. It is under those circumstances, my lord, we had withheld the submission of. This is a right, my lord, to the institution in respect of recovery of the amount of 3 years, which we could not recover for want of filling up of that seat. I have filed my objections. Your lordship, there's one aspect of the matter. Second thing is, my lord, he has already, my lord, withdrawn.
After he had given up the seat, another round of counselling was held, right?
Yes, my lord.
30th May 2011, another round of counselling was held.
Yes.
Then who prevented you from filling up the seat?
In the second round of counselling, my lord, well, I'm not very much sure about filling up the seat, my lord. If the seat is filled up, there is one thing. But so far as prayer number C is concerned, he himself has withdrawn. Therefore, the question of, my lord, restoring that thing would not arise.
That does not arise. We think that 7 lakhs and odd rupees is a good compensation for you. Especially when another round of counselling was held for that very seat.
I have produced, my lord, the copy of the division bench decision, my lord, wherein the collecting, my lord, of the bank guarantee and also the amount, my lord, has been confirmed by this honorable court because taking into consideration, my lord, our right to recover the money.
But before last day,
yes,
he had surrendered the seat. Thereafter, the counselling was held on 30th 5/2011. After he had surrendered the seat, please appreciate that. If he would have surrendered it after the last day, then we can understand.
This 30, so far as second counselling is concerned, my lord, I will have to just verify and make my submission, my lord.
No, nothing verified. Now, after 3 years, what to verify?
No, because subsequently, my lord, this subsequent submission which he has made, my lord, that the second round of counselling has taken place.
Petition itself. It is written in the writ petition itself in para 6 in 2018. That subsequent round of, it's not that you are being taken by surprise. You have filed objections to this.
For that, my lord, your lordship kindly see the objections, my lord, which I have filed.
So, para 6, please come to para 6 of the writ petition.
Yes, my lord, yes.
Please read. What is your reply to para 6?
It is further submitted that the third respondent has conducted another round of counseling on 35/2018. The true copy of the notification also. Hence, it is clear that the petition has surrendered the seat well in advance, and the KE has conducted another round of counseling after the petition has surrendered the MD psychiatrist seat. Now, for that, my lord, and seventh para, my lord, we have sought for a refund of that amount. You lordship kindly go to statement of objections below, which I have filed below. Para 7 may kindly be seen, my lord. This respondent on surrendering of the seat on 24/5/2018, a communication is made by the Dean of College to the Executive Director on 25/5/2018. To revert back the vacancy of the seat to the institution as on. So this is followed by a similar request letter to the Director of Medical Education on 25/5/2018 to permit the college to admit any eligible candidate through the list sent to the KAE by merit in the same subject as among so and so. The petitioner has volunteered to not to continue with the course after being admitted to the course. Once having been admitted to the course, he has to necessarily pay the entire course fees of all the 3 years. And thereafter, he has to seek return of the documents and not otherwise.
Yes, please.
My lord, I think I am audible, my lord.
Yes, you are audible. We are listening you. Yes, please go ahead.
Now, my lord, in para 8, para 7, I have said that
Initially
he wanted
told
to.
us. No. Initially, you told us that you have 2 submissions to make. So
That
first
is, my lord,
submission was. I don't know what are you doing. I mean, what are you trying to say? And first you said that if original documents are returned, the right to recover fee for 3 years would be frustrated.
Yes.
This was your first submission. What is the second submission?
Second submission is that, my lord, on 24/5/2018, my lord, after surrendering of the seat, we have returned, my lord, to the Executive Director of the Karnataka Education Society, Association, requesting to revert back the vacancy of the seat institution. That has not been done. That has to be answered by the advocate for KEA. And thereafter, my lord, similar request was made to permit the college to admit any eligible candidate through the list. This has not been so permitted, my lord. And thereafter, my lord, we have.
Please appreciate that cause cannot be adjudicated in a writ petition filed by the student. You should have you should have taken appropriate action against KEA at that point of time. Not this thing in a writ petition filed by respondent, by the petitioner. Can we adjudicate this issue?
Because ultimately, my lord, at his instance, my lord, we have lost 1 seat and also the fees for 3 years, my lord.
For which provision you have to right to recover? And he has to pay all. Where is that?
That is copy of the division bench petition, my lord, along with the memo I have filed, my lord.
What petition?
This is a petition.
Right.
with reference to my lord, Islamic academic case, it must be mentioned, para 8, my lord, para 10. We have perused para 8 of the judgment in Islamic Academy of Education. On reading of para 8 of the judgment, we are of the view that Honorable Supreme Court has not ruled that a college cannot demand for the fees for the rest of the semester or academic year if a student leaves the college in the midstream. For better understanding of the judgment of the Honorable Supreme Court, it would be appropriate for us to quote para 8. It must be mentioned that during arguments, it was pointed out to us that some education institutions are collecting in advance the fees for the entire course. That is all for all the 3 years. It was submitted that this was done because the institute was not sure whether the student would leave the institution midstream. It was submitted that if the student left the course in midstream, then for the remaining years, the seat would lie vacant and the institute would suffer. In our view, an education institution can only charge prescribed fees for 1 semester per year. If an institution feels that any particular student may live in the midstream, then at the highest, it may require that student to give a bond bank guarantee that the balance of fees for the whole course would be received by the institution, even if the student left in the midstream. If any education institution has collected fees in advance, only the fees for of that semester per year can be used by the institution. The balance fees.
That is the answer. You have collected the fee for that semester. We are permitting you to retain it in view of Islamic education. That's the answer. You cannot demand.
Ultimately, madam, we have lost the seat with the 3 years fees.
Please understand, he has not left the course midway. Before the last date, he surrendered the seat.
Please,
thereafter, the counseling was held. So Islamic Education Academy is against you, right? It says that you can only appropriate.
But in a given case, my lord, we can insist, my lord. That is the para 13, my lord, if your lordship kindly permit me, my lord. Para 12 and 13, my lord, would be, because ultimately it's a concluding paras, my lord, kindly permit me. Therefore, we are clear that the Honorable Supreme Court has ruled that in advance for the whole course, the college cannot collect the fees. And if the college is of the opinion that the student may live in the midstream, then it can demand a student to execute the bond by bank guarantee for the balance of fees for the whole course. Therefore, the learned single judge, while considering the case of Vikas P. so-and-so, has wrongly interpreted para 8 of the judgment of the apex court and has erroneously granted relief to the petition therein. In such circumstances, if another single judge, without expressing any opinion of the judgment of the learned single judge, referred the matter to the division bench on careful consideration of para 8 of the judgment of the Honorable Supreme Court in Islamic Academy versus so-and-so, we are of the opinion the Honorable Supreme Court never ruled that the college cannot demand the student who live in the midstream for payment of balance fees for the whole course. As rightly pointed out by Mr. Naik, the learned counsel, the learned senior counsel for the respondent Bhavan, that on account of the petitioner getting a BBS seat for the next academic year, the petitioner cannot cause loss to the institution. As a matter of fact, we are of the view that the petitioner leaving the course in the middle has deprived of the government seat to any other eligible candidate for BDS course under the government quota. Now, on account of her conduct, she not only caused loss of revenue to the first respondent college, deprived a seat for another eligible student who was willing to become a dentist. We are also of the opinion a time has come to the government to make a proper rules to prevent changing the course unnecessarily, which would result in depriving the chance of getting government seat of any other meritorious candidate. We are of the view that if the petitioner was inclined to take MBBS seat, she could have taken chance in the next academic year. Without doing so, opting a BDS course, she has given up the seat in the midstream. Therefore, a time has come for the government to make necessary amendment to the rules to plug such loopholes. In the result, we dismiss the petition. The bank guarantee executed by the petitioner is ordered to be invoked by the respondent, and we hold that the order passed by the single judge so-and-so below is incorrect. I am only emphasizing, my lord, that the college, my lord, has lost 1 seat, my lord, and the government has also lost 1 seat because of the conduct of the petitioner, my lord. Secondly, my lord, we have lost, my lord, 3 years fees.
That's it.
Yes, my lord.
Again. Okay. Thank you.
If I may just clarify one factual aspect, my lord. I have not left the course midstream after joining the course. I just wanted to clarify.
But we can't make him understand. We are telling him that you have left it before 31st. Thereafter, one round of counseling has been held. But if he repeatedly says, we are not sitting here to convince him that,
Like,
we will say that in our judgment.
like.
Petitioner inter alia seeks the writ of mandamus. Citing respondents number 2, 3, and 5 to return all the original documents submitted by the petitioner to Karnataka Examination Authority at the time of issuance of order of admission dated 16/5/2018, and as well as a direction to respondent number 5 not to insist on payment of tuition fee of rupees 25,32,000 for the entire duration of 3 years of MD psychiatry course. The petitioner also seeks a writ of mandamus directing the Karnataka Examination Authority and the respondent number 5 to refund the fee of rupees 7,74,500 deposited by the petitioner at the time of issuance of at the time of admission to the aforesaid course on 16/5/2018. The inter alia has played for non paragraph. That's leading to filing of this petition. Paragraph next. That's leading to filing of this petition stated that the petitioner completed MBBS course from Government Medical College Amritsar in the state of Punjab and was conferred the MBBS degree by Baba Farid University of Health Sciences, Punjab. Full stop. Petitioner appeared in the postgraduate national eligibility cum entrance test 2018. The
much smaller than Saturn and Jupiter. Unlike any other
registered with
solar system,
Karnataka Examination Authority, which is the designated authority for conducting counseling for admission to PG medical courses in the state of Karnataka. The petitioner was not allotted any seat in first and second round of counseling conducted by Karnataka Examination Authority. Petitioner had also applied for admission to PG medical courses in Baba Farid University of Health Sciences, Punjab. The candidature, the candidature of the petitioner was not being considered for admission. Therefore, he filed a writ petition before the High Court of Punjab and Haryana for a direction to the university to consider the case of the petitioner for admission to PG medical course as per his ranking in PG NEET examination 2018. In pursuance of the directions issued by High Court of Punjab and Haryana, the petitioner was granted admission in Christian Medical College in MS Orthopedics and was admitted to the course on 24/5/2018. The petitioner had also participated in the mop-up round of counseling conducted by the Karnataka Examination Authority on 16/5/2018 and was allotted a seat in MD Psychiatry course in the college run by respondent number 5. The petitioner thereupon deposited a sum of rupees 7,74,500 as well as all his original documents with the Karnataka Education Authority. However, subsequently, when the petitioner was admitted in Medical College Ludhiana in MS Orthopedics course, the petitioner immediately informed the Karnataka Examination Authority as well as the respondent number 5 college by an email dated 24/5/2018 that he is surrendering his MD Psychiatry seat in MD Psychiatry course, respondent number 5 Medical College. It is pertinent to note that last date for counseling to the KG courses was 31st of May 2018. The petitioner thereafter visited Bangalore and submitted a communication to respondent number 2 and informed that and stated that he is surrendering the seat and requested for handing over the original documents. The petitioner thereafter submitted a representation on 28/5/2018. After the petitioner had paragraph, it is pertinent to mention here that the petitioner had surrendered his seat prior to last date of counseling and much before commencement of the course. So stop. The petitioner, after the petitioner had surrendered the seat, Karnataka Examination Authority had conducted another round of counseling on 30/5/2018. 30/5/2018. The respondent number 5 thereafter sent a communication dated 3/6/2018 to the petitioner to deposit a sum of rupees 25,32,000. Thereupon, in the aforesaid obtaining factual matrix, the petitioner has approached this court seeking the reliefs as is stated to paragraph. Counsel for the petitioner, while inviting the attention of this court to an interim order dated 24/4/2019 by the division bench of this court, fairly stated that in compliance of the aforesaid order, the original documents have already been returned to the petitioner and the petitioner has already given up the relief of refund of rupees 7,74,500, which was deposited by the petitioner. It is further submitted that in view of law, Mr. 2003 volume 6, in view of law laid down by Supreme Court, it is further submitted that the respondent number 5 is not entitled to seek the payment of the whole course fee for a period of 3 years from the petitioner, as the petitioner had petitioner had given up the seat much prior to last date of counseling and much before commencement of the examination. So, on the other hand, learned counsel for respondent number 5 submitted that if the original documents are returned to the petitioner, the right of the management to recover the fee for 3 years would be frustrated. It is, however, admitted by learned counsel for respondent number 5 that after the petitioner had surrendered the seat, another round of counseling was held on 30th 5 2018 by Karnataka Examination Authority. It is submitted that it is urged that since the petitioner had not prosecuted the course, therefore the respondent number 5 was deprived from admitting any person to the course in question and therefore is entitled to recover the fee from the course fee of entire 3-year course from the petitioner. In support of this submission, learned counsel for the petitioner, respondent number 5 has placed reliance on Islamic Academy of Education and another versus State of Karnataka and others, 2003, Volume 6, SCC 697, paragraph. No, has placed reliance on division bench decision of this court dated 18th of March 2014. In the case of Miss Smruti SMRUTHY BS versus DA Pandu PANDU Memorial. We have considered these submissions on both sides and have filled the record. Therefore, in that Islamic education, so and so, you have the citation 2003, so and so. So and so. And so in paragraph 8 of the report, has held that educational institutions can only charge prescribed fee for 1 semester stroke year, and if an institution feels that any particular student may leave in midstream, then the highest it may require that student to give a particular highest it may require that student to give a bond to bank guarantee that the balance fee for the whole course would be received by the institute if the student is left in midstream. It has further been held that if any educational institution has collected fees in advance, only the fee of that semester stroke year can be used by that institution. Slide 11 of the date of the offensive decision is expected below for the frequency of reference. Page 722. Paragraph. Thus, how you say maybe like this. That thing should come here. No. The influential, huh? The Supreme Court in para 8 has held under which is reproduced below. Now you write the thing has held like this, right? Thus, evident that the institution has only a right to recover for fee of recover prescribed fee for one semester stroke year. In the instant case, the petitioner has not left the course midstream. The petitioner has admittedly surrendered the seat. On 24/5/2018 before the last date of counseling. It is also not in dispute that after the petitioner had surrendered the fee, another round of counseling was held on 30th/5/2011 by the Karnataka Examination Authority. Full stop. It is not a case where the petitioner has left the course midstream. Full stop. Therefore, in view of law laid down by Islamic Academy of Education, the respondent number 5 has no right in law to demand from the remaining course fee of 3-year course from the petitioner. Paragraph. Since admittedly in compliance of the order dated 24/4/2019, the original documents have been returned to the petitioner. The interim order has already been given effect to. Therefore, the prayer for return of original documents does not survive. The petitioner by an order. Petitioner has already given up the right to seek refund of ₹7,74,500 deposited by him as is recorded in the order sheet. Therefore, no orders are required to be passed with regard to prayer clause C. Stop. Accordingly, it is said that that's all. It is already done. Thus, for the aforementioned reasons, the rate petition is disposed of in terms indicated.
Obliged.
Much obliged.
My lord, serial number 41, my lord. My lord, I pray for 4 weeks time, my lord. I have been tested positive for COVID. My lord, I am required to file my objections, my lord.
I appear for petitioner.
My lord, I appear for respondent. I pray for 4 weeks time, my lord.
Total mic is muted.
Yes, granted. 4 weeks time granted.
Much obliged, my lord.
Please.
I appear for the petitioner, my lord, 42, 43, and 44.
I'm for adjournment.
10 days time, my lord. Kindly be granted.
Mr. T.P. Mutanna, learned counsel for the petitioner, submits that he has recovered from COVID and prays for adjournment to enable him to argue the case. List after 10 days, 42, 43, 44.
Much obliged.
File hearing. Number 45.
My lord, serial number 45, 46, and 47. I apologize, my lord. We have prepared a synopsis. We'll place it. It may be had any date next week, my lord.
Prays for adjournment. List 44, 45, 45, 46, 47. His password.
Password matter.
Grateful, my lord.
29.
And appears for petitioner even when the matter is called in second round. Let a copy of the writ petition be supplied to learned counsel for the KVHF. Same order in 30. All proceed.
35. From ready. CKT Govinda Gowda.
None for petitioner even when matter is called in second round. Wait, none for parties. Awaiting appearance of learned counsel for the parties. Hearing of the appeal petition is deferred. List after 10 days.
CM Lover.
Appear for appellant, my lord. Your lordship, in these cases, my lord, there are two batches of cases, my lord. One filed by the revenue, another filed by the assessee, my lord. In respect of the same issue, the matter is pending before the Honorable Apex Court. In Apex Court also, there are two SLPs, my lord. One filed by the revenue and another filed by the assessee. So these matters may kindly be deferred, my lord.
Yes. Mr. E.I. Sanmati, learned counsel for the revenue submits that issue involved in this batch of appeal is pending adjudication before the Supreme Court. He therefore prays for adjournment in view of opposite submission. Hearing of the appeals is adjourned, is deferred. However, learned counsel for the parties are granted the liberty to mention the matter as and when SLP is decided.
Lord, may I make one submission in serial number 45, 47, 45, my lord. I was on this thing, my lord. I could not hear what my lordship.
It has been adjourned next
Please,
week.
please, great. I'm sorry, my lord. I'm sorry.
Number 49. CA Sanmati. Srimati Tanmay Rajkumar.
Appear for the respondent, my lord.
Appeal for the appellant, my lord. Your lordship, in this case, your lordship, this is the appeal filed by the revenue, my lord. 49 and 50 are connected matters, my lord. Your lordship, this is the appeal filed by revenue. Your lordship, 458 of 2019, your lordship is having, my lord.
Yes.
Your lordship, in this case, my lord, the assessee claims to be a trust. In this case, my lord, the assessee claims to be a trust, my lord, and had sought registration under section 12A of the Act, my lord. Lordship, the same came to be rejected by the Honorable Commissioner of Income Tax by order dated next year B, my lord, page number 12. With order dated 28/9/2018. So, Lordship, this rejection order was challenged before the Honorable Tribunal, my lord. The Tribunal has allowed the appeal filed by the assessee, my lord, at Annexure A, which is dated 15/3/2019, my lord. So, Lordship, in the connected matter ITF 459 of 19, my lord. Only difference is, my lord, in this case, it is 80G, my lord. And it came to be rejected, my lord, by order dated Wide order dated, my lord. Your Lordship, 28/9/2018, same date, my lord. 28/9/2018. Appeal was filed by the assessee before the tribunal, and the tribunal has allowed the appeal of the assessee by holding that ATG benefits are available to the assessee. Wide order dated 15/3/2019, annexure A, my lord. So, Lordship, yes, my lord. Now the tribunal has held, my lord, the assessee is entitled for 12A registration as well as ATG registration. Whether the assessee is entitled for that sort of exemption is the question before this honorable court, my lord. At page number 4, my lord, I have raised 4 questions, my lord. Common questions have been raised in both the cases, my lord. May I read the question, my lord? Page number 4, first question, my lord. Whether on the facts and in the circumstances of the case, the tribunal is right in directing the Commissioner of Income Tax to grant registration under Section 12A and consequently under Section 80G of the Act, as well as ignoring the fact that though the assessee trust was formed predominantly for carrying out commercial activities such as construction and development, ignoring that no charitable activities were carried on by it until the date of application for approval under Section 12A as well as 80G of the Act. Second question, Lord, whether on the facts and circumstances of the case, the tribunal is right in not appreciating the fact that the assessee has failed to approve the financial statements and activities carried out earlier, that they are charitable in nature as provided under Rule 11AA3 of the Rules 1962. Next question, Lord, whether on the facts and circumstances of the case, the tribunal is right in not considering the fact that the satisfaction on the part of the authority granting approval for recognition under Section 12A and 80G is necessary in terms of set provisions of the Act read with Rule 11AA of the Act. Next, my lord, whether on the facts and circumstances of the case, the tribunal is right in not following the decision of this honorable court in the case of the Ganjam Nagappa and Son Trust Supra, wherein it has been held that grant of exemption or renewal is not automatic in character in allowing the assessee's appeal. So, Lordship, may I read Section 12A for a moment, my lord? Lordship, page number 1.187, my lord. Your Lordship, may kindly see conditions for applicability of Section 11 and 12. Your Lordship, the provisions of Section 11 and 12 and Section 11 and Section 12 shall not apply in relation to the income of any trust or institution unless the following conditions are fulfilled. Namely, there are certain conditions, my lord. To get exemption under 12A, my lord, the assessee has to file an application before this Commissioner of Income Tax. Your Lordship, 12AA(b)(2), my lord, at page number, my lord, 1.192. If an application is filed, what is the procedure for registration? Section 12AA, my lord. Your Lordship, procedure for registration. The principal commissioner on receipt of an application for registration of a trust or institution made under clause A or clause AA or clause AB of subsection 1 of Section 12A shall call for such documents or information from the trust or institution as he thinks necessary in order to satisfy himself about. Your Lordship, first clause deals with genuineness of activities of the trust or institution. Second clause deals with the compliance of such requirements of any other law for the time being in force by the trust or institution as or material for the purpose of achieving its objects, and may also make such inquiries as he may deem necessary in this behalf. Your Lordship, clause B, my lord, after satisfying himself about the objects of the trust or institution and genuineness of its activities, your Lordship, as required under subsection clause I or clause A and the compliance of the requirements under subclause I of the said clause, your Lordship, Roman I, my lord, down below, shall pass an order in writing registering the trust or institution, shall, if he is not satisfied, pass an order in writing refusing to register the trust or institution. In this case, he was not satisfied with the objects of the trust. Your Lordship, since he has rejected it. Your Lordship, one more rule, my Lord, Rule 11AA, my Lord. Your Lordship, Rule 11AA, page number 1.191, my Lord. Your Lordship, in the head, my Lord, it is the amended provision, unamended, which is applicable to facts of this case, my Lord. Down below at footnote, my Lord, at the footnote 3, footnote 81, my Lord, subclause 3, my Lord. 3. The commissioner may call for such further documents or information from the institution or fund or cause such inquiries to be made as he may deem necessary in order to satisfy himself about the genuineness of the activities of such institution or fund. Since in this case, he, after going through the various documents, the commissioner was not satisfied about the objects of the trust. Your Lordship has rejected it. Your Lordship may read the order passed by the commissioner, my Lord, at page number 12. Your Lordship, paragraph number 2, my Lord. It starts with the wordings, my Lord. The applicant trust.
Yes.
The applicant trust filed details or clarification on 29/2018. The settler of the trust is developer cum builder. The trust is basically a builder and property developer engaged in commercial activities. As per the deed, they are the executors and administrators of the trust. Under the circumstances, one of the primary object is erection, construction, and maintenance of townships and housing, which indicates the purposes of the formation of the trust, which is not on a charity mode, but with the commercial intention. The construction of township in which the settler is primarily engaged, the same is objectionable. Para 3, my Lord, even in objective number 3, Roman 2, my Lord, indicates the primary object of the trust is erect, equip, and experimenting community living and collective living is also in relation to the primary business of the settler. In particular, object number 3.5 of the applicant trust is very clear of the commercial intention. For example, the objective says to assist, to establish, to promote any industrial and commercial activities to make profits, to support the trust. Commercial activity can be an incidental of a charitable trust as per section 215 of the IT Act 1961. That too, the receipts should not have been exceeded the specific limits. Under the circumstances, the object of the assessee trust itself is promoting and establishing industrial and commercial activity, which is objectionable. Next page, Lord. Further, the attention is drawn to column number 5 of page number 14 of the trust deed, which reads as under: the trustees shall be entitled as at such time or time as they think fit and at their absolute discretion to sell and convert the trust funds or any portion thereof into any other property which the trustees are authorized to hold in accordance with the terms of these presents. The above discretion of the trust is to sell and convert and trust properties and funds without meeting the requirement and necessary of the trust, which is objectionable at the stage of registration under section 12AA. The commissioner, in receipt of an application for the registration of a trust or institution, has to satisfy himself about the objects of the trust or institution and the genuineness of the activities. In the absence of relevant details, it is not possible to verify the genuineness of the objects and activities of the trust in this case. In this connection, reference is placed on the following decisions. Decisions have been quoted below. In the last paragraph, para 4, my lord, it is subject to the satisfaction of the authority with regard to the charitable character and with regard to the applicant's activities in items in terms of Rule 17A, only on being satisfied, registration of renewal is permissible. That is also extraction, my lord. The next one, further it appears that the applicant is not registered interested in in processing of this application and therefore deserves to be dismissed on this account. The law assists those who are vigilant and not those who sleep over their rights. This principle is embedded in well-known dictum, vigilance, non-dormative jurisdiction civilian courts. In several cases have upheld this dictum. Lack of diligence and follow-up on the part of the assessee has been frowned upon by various courts as under. Decisions have been quoted. In the next page, considering the facts and circumstances of the case as detailed above, the application for registration under section 12AA is hereby rejected. Your Lordship, the main ground on which it has been rejected is that the assessee is in the commercial venture, which is involved in the business of erection, construction, and the dominant object of the trust is for erection, construction, and it is a commercial activity. So it cannot be, it is not entitled for 12-year registration, my lord. And the primary object and dominant object has been considered by the authority. On this, my lord, appeal was referred before the tribunal. The tribunal, my lord, at page number 6, my lord, the order starts, my lord, and the reasoning starts at page number 7, my lord, para 3. We have considered the reasons given in the petition for condonation of delay. Your Lordship, this is with regard to delay, my lord, para 5, my lord. Para 5. The assessee is a trust. The assessee is a trust which came into existence pursuant to a registered deed of trust dated 21/2/2018, executed by Messrs. Embassy Property Developments and Private Limited. The main object for which the trust was created for the purpose of advancement of educational objects or purposes. Clause 2B of the trust deed provides that the trustees at their discretion use the fund wholly or in part or parts on such public educational purposes, including spiritual activities which are beyond any specific religion, research in human consciousness, well-being and education of mentally retarded children, adults, research in collective and community living in harmony, unity and peace, and any purpose that the law and provisions of the Income Tax Act 1961 regard as educational purpose. The assessee made applications on, this is with regard to facts, my lord, para 7, my lord. The next relevant part I will read, my lord. And the CITA in the impugned order rejecting the application for grant of registration under section 12A of the Act observed that the author of the trust was a property developer and engaged in commercial activities. According to the CITE, Clause 3I and 2 of the trust deed provided that the trust shall erect, construct and maintain township and housing, and therefore the trust was not formed with charitable motive but with commercial intention. On the above reason given for the rejection of registration, the learned counsel for the assessee has pointed out that the relevant clauses has to be read in conjunction with the preamble in Clause 3 of the trust deed, which clearly lays down that the above activities were to be carried out in furtherance of the object of providing education. The CITA, in our view, has overlooked the fact that all the activities spring from and are to be read in conjunction with the clause 2B of the deed of trust, which we have extracted in the earlier part of this order. Another reason given by the CITA for rejecting the application of the assessee for grant of registration under section 12A of the Act was that the clause 3.5 of the trust deed permitted the assessee to establish, promote any industrial and commercial activity with the condition that the proceeds from such activities should be utilized for supporting educational activities. According to the CITA, the above clause showed that the objects of the assessee were not charitable within the meaning of section 215 of the Act. The learned counsel for the assessee has drawn our attention to a decision of the Honorable Madras High Court in the case of DIT versus ITO Chennai chapter reported in so and so, wherein the Honorable Madras High Court upheld the order of the tribunal, which held the registration cannot be refused on the ground of incidental objects to attainment of main objects being commercial in nature. The next reason, Your Lordship, this is also reasoning given by the Commissioner, my lord. The para 10, my lord. We are of the view that none of the reasons given for refusing registration to the assessee are acceptable. The objects of the assessee are charitable in nature, being solely for the purpose of education, and all activities spring from and are to be read in conjunction with clause 2b of the deed of trust, which have extracted in the earlier part of this order. There are sufficient safeguards in the act in the event of the object not being carried out in accordance with the deed of the trust, or wherever there is personal benefit. There is nothing brought on record by the CITA to show cause the objects of the assessee are not charitable and its activities are not genuine. In the circumstances, we are of the view that the assessee ought to have been granted registration under section 12AA of the act. We direct that the registration under section 12A being the allowed to the associate. My lord, Your Lordship, further, my lord, the Honorable Karnataka High Court in the case of DIT versus DR Lanka Charitable Trust reporting has laid down that at the time of registration under section 12A, the charitable object of the assessee and the genuineness of its activities has to be seen, and it is only in the assessment the actual activities, whether charitable or not, has to be seen. Similarly, in the case of CIT versus AS Kuppuraju Brothers Charitable Foundation Trust reported in so it was held that the registration cannot be refused on the ground that main purpose of the creation of the trust was for the some other ulterior purpose. The above decision support our conclusions that the assessee should be allowed the benefit of registration under section 12A of the act. Moreover, the grant of registration under section 12A of the act does not automatically enable an assessee to claim the exemption under section 11 and 12 of the act. The AO, even in a case where a trust or a charitable organization for which registration under section 12A of the act subsists, has to go on into the question as to whether the income has been applied for charitable purposes and to the extent contemplated by section 11 and 12 of the act. Even in a case where the trust or charitable organization applies its income for the charitable purposes but does not have registration under section 12A of the act, such a trust or charitable organization cannot claim the benefit under section 11 and 12 of the act. Thus, the appeal is appeal by the assessee is allowed. So, Lordship, the main grounds on which the appeal came to be allowed, my lord, the tribunal has come to a conclusion that the assessee is involved in rendering educational. There is object with regard to education. The specific wording used, my lord, in para 10, being solely for the purpose of education. In para 10, my lord. In being solely for the purpose of education, Your Lordship, and all other, according to the tribunal, all other remaining objectives has to be read in conjoint with the purpose of education. And all other activities spring from and are to be read in conjunction with clause 2b. That means the assessee tribunal is giving relief to the assessee on the ground that it is involved in main object is for the purpose of education. That is the first ground, my lord.
Where is the deed of trust?
Your Lordship, yes, my lord. Your Lordship, the trust, my lord, trustee has been placed on for this honorable court by the assessee's council, my lord, in white paper book, my lord. Your Lordship may kindly have the paper book filed by the assessee, my lord.
My lord, I have submitted the paper book filed before the tribunal, which contains the trustee.
Your Lordship, it starts with page number, my lord. Page number 15 of the paper book, my lord.
It's a paper book filed before the income tax tribunal, which was as it is filed.
Both the book. Take it.
Your Lordship, till then, my Lord, may I take your Lordship through decisions, my Lord.
Page 15.
Page 15, my Lord, trust deed, your Lordship gets it, my Lord. Printed page film.
6.
Page 15, trust deed, my Lord. May I read the description of the trust deed, my Lord, in the first introduction part.
Yes, read from page 13. 13, clause 1. Establish, erect, equip, retain, contribute, establish, erection, construction, maintenance of research centers, spiritual centers, bodies, establishment, townships, halls and housing,
Your Lordship,
room, meditation halls,
Your Lordship,
library.
it runs to several pages, my Lord. May I read only that part which is relevant according to the revenue, my Lord? Your Lordship may kindly see, my Lord, in the page number 15, my Lord, your Lordship will get that this deed of settlement. Printed page, my Lord, on the top, right side top corner, my Lord, printing is there, my Lord, printed page numbers.
Beginning of the document.
Your Lordship, trust deed, my Lord. Your Lordship may kindly see this deed of settlement made at Bangalore so and so date, my Lord. And Your Lordship, private, Your Lordship, Property Developments Private Limited, a company incorporated under the Companies Act 1956, having its registered office at so and so date, my Lord. The settler, represented by its authorized signatory, Mr. So and so, my Lord, shall, unless repugnant to the context of the meaning thereof, mean and include embassy the property developments private limited, its sites, executors, and on the one part and other the and Sri so and so, my Lord, the both Bangalore Libertans or herein of the trustees. These are the trustees, my Lord, and it is a company forum, company, my Lord, which has formed this trust. Your Lordship, the next page, my Lord, page number 17, clause 2, my Lord. Clause 2, my Lord, in furtherance of the desire for advancement of educational objects or purposes, a settler has intended to create a trust called Embassy Charitable Trust, hereinafter referred to as the trust, as a central institution for carrying out public educational objects and purposes wide enough for the extension of the benefit thereof to all, irrespective of the class, community, creed, and religious. Your Lordship, next relevant part, my Lord, at page number. Your Lordship, page number 20, 28, my Lord. Sorry, 25, my Lord. 25, provided further under the heading, my Lord. Under the heading provided further, my Lord, that notwithstanding anything herein before or herein after contained, the income as also corpus of the this trust fund shall be applied and are applicable only to and for the such educational purposes and objects, and which such territories only and subject to such conditions. Only I'm relying upon that particular wordings, educational purposes. The next one, my Lord, page number 13, Roman I, my Lord, 3I. Page number 28, my Lord, Roman 3I, my Lord. Your Lordship, Roman I, my Lord, to establish, erect, equip, and maintain or construct or aid towards establishment, erection, construction, maintenance of research centers and or spiritual centers, bodies or establishments, townships, my lord, halls and housings needed for such pursuants to assist activities such as forums, workshops, schools, mediation halls, reading rooms, libraries, homes, gardens, furnishings to provide for physical and other needs for or such spiritual life facilities to provide for publications, producing needs or the establishment and inmates and to aid and in general any non-religious spiritual activity aimed at raising human consciousness, mediation, yoga practices, yogic centers for development of health, hygiene and body, experiment in peaceful, harmonious, truth-seeking human life on this earth and urge to aid any or aiding others to promote such a life. This Roman 2, my lord, to establish, erect, equip or maintain or contribute or aid towards establishment, erection, construction, maintenance of townships, research centers, communities, bodies of people. This is also with respect to same object, my lord. That is with regard to erection, construction and maintenance of townships. The next clause which I rely upon, my lord, next page, my lord, clause 5. To assist, to establish, to promote. Your lordship gets it, my lord.
Yes, yes.
To assist, to establish, to promote any industrial or commercial activity or activities whose entire proceeds are utilized for supporting for the benefit of activities and in 3I and 3.1. To establish and to promote any industrial and commercial activity, my lord. And in the next page, my lord, Roman 11. To establish, promote, assist educational instructions, encouraging literature, arts, medicines, science, crafts, history, technology, education in all branches. In the next page, my lord, page number 31, 5, in 31 page, my lord, clause 5. The trustees shall be entitled at such time or times as they think fit and at their absolute discretion to sell and convert the trust funds or any portion thereof into any other property which the trustees are authorized to hold in accordance with the terms of this presents. The next page, clause 6, my lord. Clause 6, my lord. All monies forming. Yes, not all monies for.
Today they are going to Webhost in the evening.
Lordship.
Yes, Mr.
Lordship, all monies forming part of the trust funds and requiring investment shall be invested in the name of the at least 2 of the trustees for the time being of this presence in or upon any of the securities authorized by law, including the Income Tax Act 1961 for the investment of funds or upon the purchase or legal mortgage of the immovable properties. Lordship, this shows that they have to invest in this, the name of these two trustees, my lord, not in the name of trust. In the next page, my lord, clause number 7, page 33, it shall be lawful for the trustees to pay or transfer any property held by them under these presents to any person or persons or to a corporation who shall undertake to apply the same for or towards such purpose mentioned in this deed as may be determined by the trustees without the trustees being responsible or liable for any loss or misapplication thereof. Lordship, all these classes, which have been relied upon by the commissioner, my lord, shows that it is a commercial venture. Your lordship may kindly see, these classes have been relied upon by the commissioner. The tribunal, without going into the contents of this entire trust deed, only on the basis that it is a object is for education, gives relief, my lord. Your lordship. Your Lordship, the tribunal has not gone into all the objects given in the trust. It has specifically chosen in respect of these educational objects and says that that is the main object and all other are incidental. And they have to be read in conjoint. Your Lordship, my respective submission is that the tribunal has misread this, my lord. If it is for the purpose of education, the assessee is not the assessee has to go under section 1023C, my lord. It is for the education. If it is for educational purpose, your Lordship may read this section 215 charitable purpose definition, my lord. Lordship, page number 1.10, my lord. Definition clause 215, my lord, 15. 1.10, my lord. Charitable purpose includes relief of the poor, education, yoga, medical relief, preservation of environment, including water, shields, forest, wildlife, and preservation of monuments or places or objects or artistic or historic interest, and the advancement of any other object of general public utility, provided that the advancement of any other object of general public utility shall not be a charitable purpose if it involves carrying on any activity in the nature of trade, commerce, or business, or any activity of rendering any service in relation to any trade or commerce or business for cess or fee or any other consideration, irrespective of the nature of the use or application or retention of the income from such activity, unless. Your Lordship, I will not go into that one, my lord. Your Lordship, on the right side down below, it is unamended provision earlier to amendment, my lord, which is also in respect of the same terms. Only I am drawing your attention, my lord, with respect to this charitable purpose definition for a limited extent that the education wording, my lord. Your Lordship, it includes relief of the poor, education, or medical relief, or everything. Your Lordship, the education is not defined under the Act, my lord. Your Lordship, for the purpose, if the trust wants to involve only in respect of this education, my lord, it has to apply under section 1023C, my lord. For the purpose of education, my lord.
Purpose of education is a charitable purpose. That's what the definition is inclusive.
Yes, my lord. Your Lordship, the contention of your Lordship, the tribunals has said that it is for educational object, they are entitled for 12A. Your Lordship, one direct decision of the Honorable Apex Court, what is education, my lord? I have placed it in my paper book, my lord.
Yes.
Your Lordship, in serial number, your Lordship, the last case, my lord, sole trustee Lok Sabha Sikshana Trust, my lord.
Which case?
Your Lordship, page number, my lord, page number 25, my lord.
25.
Your Lordship, this is sole trustee Lok Sikshana Trust versus Commissioner of Income Tax, my lord, reported in 1975 CTR, page 281, my lord.
Yes.
Your Lordship, what is education, my lord? It is at your Lordship, para 24, page 33, my lord. In para 24, my lord, the Honorable Apex Court has relied upon the earlier decision, my lord, in the case of Privy Council, my lord. Para 24, my lord, the charitable purpose definition has been extracted, my lord, by relying upon the decision in the case of Privy Council in the Tribune. Now, see the relevant part, my lord. Your Lordship, para 32, my lord. Page number 35, my lord. Yes. Your Lordship, we are in agreement with the view expressed by the Tribune case to the extent that we think that a trust with such as the one considered there does not just like the trust before us fall within the category of education as such mentioned in the statutory elucidation of charity, which was repeated in the 1961 Act with an added qualification of the last and widest category. Although the term education as used in section 215 of the Act seems wider and more comprehensive than education through educational institutions such as universities whose income is given an exemption from income tax separately under section 1022, provided the income is given an exemption from the income tax separately under 1022, Your Lordship, provided the educational institution concerned does not exist for the purposes of profit, yet it seems to me that the educational institution educational effects of a newspaper or publishing business are only indirect, problematical and cute incidental, so that without imposing any condition or qualification upon the nature of information to be determined to be disseminated or material to be published, the mere publication of news or views cannot be said to be serve a purely or even a predominantly educational purpose in its ordinary usual sense. Your Lordship, next page, the purposes which are concerned no doubt parade under the guise of caption of education. They are found stated in clause 2C. This clause speaks of supply of organs of educated public opinion to Kannada speaking people and of a presumed need for useful information and ventilation of views on matters of public utility. It is left to the trustee to decide which class of people is educated. Worship, I'm sorry, Mr.
Why are you reading this? Please tell us the proposition, then read.
Your Lordship, only relevant part I will take. Your Lordship, I will take it to relevant part, Lord.
The proposition for which you are referring to this.
Your Lordship, Your Lordship, the Honorable Apex Court has held that education means it's not education in respect of only providing of any articles, or it is a normal schooling, a systemized organization, a systemized schooling, which is not applicable to the assessee's case, my Lord. So,
this paragraph.
Your Lordship, I will just read it. Your Lordship, you may kindly come to para 41, my Lord.
Yes.
Para 41, my Lord. The sense in which the education has been.
Yes.
The sense in which the word education has been used in section 215 is the systematic instruction, schooling or training given to the young in preparation for the work of life. It also connotes the whole course of scholastic instruction which a person has received. The word education has not been used in that wide and extended sense, according to which every acquisition of further knowledge constitutes education. According to this wide and extended sense, acquisition of further knowledge constitutes education. According to this wide and extended sense, traveling is education, because as a result of traveling you can acquire a fresh knowledge. Likewise, you read newspapers and magazines, see pictures, visit art galleries, museums and zoos. You thereby add to your knowledge. Again, when you grow up and have dealings with other people, some of whom are not straight, you learn by experience and thus add to your knowledge of the knowledge of the ways of the world. If you are not careful, your wallet is liable to be stolen, or you are liable to be cheated by some unscrupulous person. The thief who removes your wallet and the swindler who cheats you teach you a lesson, and in the process make you wiser through the proper. If you visit a nightclub, you get acquainted with and add your knowledge about some of the not much revealed realities and mysteries of all this. Lordship, all this at the last conclusion, in the same paragraph, all this in a way is education in the great school of life, but that is not the sense in which the word education is used in clause 15 of 2. What education connotes in that clause is the process of training and developing in the knowledge, skill, mind, and character of students by normal schooling. My only respect to submission is that the SSC is not involved in education as defined in as defined by the Honorable Supreme Court in the case of sole trustee, my lord. The tribunal, without considering the other objects of the trust, has predominantly held that the SSC is involved in education and he is entitled for 12A. Consequently, he is also entitled for ATG. Lordship, the latest decision of the Honorable Apex Court, Lord, with regard to 12A, in what circumstances 12A application has to be considered. The guidelines, my lord, the first citation, my lord, placed by me, my lord, in the case of Ananda Social and Educational Trust, page number 1, my lord.
Yes.
While dealing with 12AA, my lord, the Honorable Apex Court, my lord, in page number 4, there are certain parameters which has to be considered by the commissioner, but that parameters have been set out. Page number 4, my lord.
Yes.
Well, the last paragraphs, which are relevant, I will read. Section 12AA undoubtedly requires commissioner to satisfy himself about the objects of the trust or institution and genuineness of its activities, and grant a registration only if he is so satisfied. The said section requires the commissioner to be so satisfied in order to ensure that the object of the trust and its activities are charitable, since the consequence of such registration is that the trust is entitled to claim benefits under section 11 and 12 of the Act. In other words, if it appears that the objects of the trust and its activities are not genuine, that it is to say charitable, the commissioner is entitled to refuse and in fact bound to refuse the registration. Lordship, he has to ensure after going through the object. Lordship, in the next page, my lord, first 3 lines, my lord. For the reasons stated earlier, we are of the view that the object of the provision in question is to ensure that the activities undertaken by the trust are not contrary to its objects, and that a commissioner is entitled to refuse registration if the activities are found contrary to the objects of the trust. Your Lordship, in this case, the tribunal has not considered the objects, Lord. There is no dispute with regard to facts. The objects have not been properly considered by the tribunal. Your Lordship, one more decision, my lord, in the case of Agarwal Sabha at page number 13, my lord.
Yes.
Your Lordship, page number 13, my lord. This is also pertaining to 12AA, my lord. Your Lordship, in the page number 15, my lord. Page number 15, my lord. Section 12AA1 of the Income Tax Act lays down a procedure which has to be followed for registration of a trust under clause A or clause AA of subsection 1 of section 12A by the commissioner. Section 12AA mandates the commissioner has to satisfy himself after calling for documents or information from the trust about the genuineness of the activities of the trust or institution and objects of the trust. In recent judgment of the Supreme Court in the case of Commissioner of Income Tax versus Dawoodi Bohra Jamaat Civil Appeal number so, it has been it has been held that section 11 and 12 are substantive provisions which provide for exemptions to religious or charitable trusts. Section 12A and 12AA lay down the procedural requirements. Section 13 sets out the circumstances in which the exemption would not be available to a religious or a charitable trust. One restriction is whether the trust or institution is created or established for the benefit of any other particular religious community or caste. In this context, while interpreting the scheme of these provisions, the Supreme Court has held that the section 13 has to be read in conjunction with provisions of section 11 and 12 for the determining the eligibility of the trust to claim exemption under the aforesaid provisions. Your Lordship, the extraction will not of the Honorable Apex Court judgment. Therefore, under the scheme of the Act, section 11 and 12 are substantive provisions which provide for exemptions available to a religious or charitable trust. Income derived from property held by such public trust, as well as the voluntary contributions received by and the said trust or the subject matter of the exemptions from the taxation under the Act. Section 12A and 12AA. Your Lordship, the parameters, the next 4 lines, my Lord. Your Lordship may kindly see section 12A and 12AH detail the procedural requirements for making an application to claim exemption under section 11 or 12 by the assessee and the grant or rejection of such application by the commissioner. A conjoint reading of section 11, 12 and 12A and 12A makes it clear that the registration under section 12A and 12AA is a condition precedent for availing the benefit unless the institution is registered.
Nobody is denying this fact. Nobody will not argue.
Your Lordship, the next provision, my Lord, the dominant nature has to be seen, my Lord. In the present case, the next, after one paragraph, my Lord, in the present case, CIT has held that the dominant nature underlying setting up of a trust. Your Lordship, in this case, the dominant nature has not been considered by the tribunal. That is the first substantial question of law raised by me, my Lord. Your Lordship, the tribunal, my Lord, the tribunal at page number 9 in para 10, last part, says, I have extracted in the earlier part. The trustee, the para 10, my Lord, appeal memo, my Lord.
Yes.
In the appeal memo, para 10, last page, we have extracted the earlier part of this. The tribunal says that the extracted portion of clause 2B of the trust deed, only on the basis of this clause 2B, holds that the assessee is eligible for 12A as it is solely involving this one educational purpose. This is highly erroneous, my Lord, and it has to be reconsidered by the tribunal by looking into the entire objects, my Lord.
Yes.
And that's all.
Yes, Mr.
May I please, Your Lordship. Lord, the commissioner, in rejecting my application for registration under section 12AA and section 80G, has considered clauses 3.1, 3.2, and 3.5 solitarily without considering the other clauses of the Act. What the tribunal basically says is that the entire trust deed, including the main object, have to be read together. Clauses 3.1, 3.2, and 3.5 are only incidental objects, the main object being education, and therefore the assessee is entitled for the registration. In sum and substance, that is what the tribunal says. And the tribunal says that also says that at the time of registration, the commissioner need not go too much into detail. All that he has to see is whether the trust deed shows what is the main object, and that main object is it a charitable object under section 215 of the Act. If after registration in an assessment, the assessing officer, it is open for the assessing officer to always go into the charitable object, whether I am really carrying on the charitable activity, and grant me the exemption under section 11 and 12. And in any case, subsection 5 of section 12AA also gives the power to the commissioner that tomorrow, if I am not carrying on a charitable activity as specified in the trust deed, he can always cancel my registration. So that power is also there to the commissioner. Therefore, all safeguards are provided to the revenue, and that is what the tribunal has said in sum and substance.
Yes, entire objects have been considered. That appears to be the main argument of the revenue. That entire objects of your trust have been considered and by the tribunal, and the finding is recorded in your favor that yes, it's charitable.
Yes, so the main objects, if my lords kindly see the trust deed, the main object is actually in clause 2B. That is my main object. Everything else.
Order.
I'm sorry, my
by order by the tribunal, please show.
Yes, my lord. If my lords kindly come to para 5.
Yes.
The SSC is a trust which came into existence pursuant to the registered deed of registration dated 21/2/2018, executed by Embassy Property Developments Private Limited. The main objects for which the trust was created for the purpose of advancement of educational objects and or purposes. Clause 2B of the trust deed, that is what is the main object. My main object is specified in clause 2B of the trust deed, which my learned friend has not read. Clause 2B of the trust deed provides that the trustee shall at their discretion use the fund wholly or in part or parts on such public educational purposes, including spiritual activities which are beyond any specific religion, research in human consciousness, well-being, and education of mentally retarded children, adults, research in collective and community living in harmony, unity, and peace, and any other purpose of that the law and provisions of the Income Tax Act 1961 regard as educational purpose. The SSC made applications. Then I'll skip para 6. Kindly see para 7, where para 7, 8, 9, and 10, the tribunal deals with each of the objections raised by the commissioner. Class 3.1, 3.2, and 3.5. And say that they are all incidental objects. They have to be read with the main object, which is under 2B. The CITE, para 7, the CITE in the impugned order rejected application for grant of registration under section 12A of the Act, observed that the author of the trust was a property developer and engaged in commercial activities. According to the CITE, clause 3.1 and 2 of the trust deed provided that the trust shall erect, construct, and maintain township and housing. Therefore, the trust was not formed with charitable motive, but with commercial intention. On the above reason given for rejection of registration, the learned counsel for the SSC has pointed out that the relevant clause has to be read in conjunction with the preamble in clause 3 of the trust deed, which clearly lays down that the above activities were to be carried out in furtherance of the object of providing education. The CITE, in our view, has overlooked the fact that all activities spring from and are to be read in conjunction with clause 2B of the trust deed of trust, which we have extracted in earlier part of this order. Another reason given by the CITE for rejecting the application of the SSC for grant of registration under section 12A of the Act was that clause 3.5 of the trust deed permitted the SSC to establish, promote any industrial and commercial activity with a condition that the proceeds from such activities should be utilized for supporting educational activities. According to the CITE, the above clause showed that the objects of the SSC were not charitable within the meaning of section 215 of the Act. The learned counsel for the SSC has drawn our attention to the decision of the Honorable Madras High Court in the case of so-and-so, wherein the Honorable Madras High Court upheld the order of the tribunal, which held that registration cannot be refused on the ground of incidental objects to attainment of main objects being commercial in nature. The next reason given by the CITE for denying benefit of registration under clause 5 was that under clause 5 of the deed of trust, the trustees had powers to sell and convert trust funds into any other property, provided the trustees are authorized to hold such property in accordance with the objects of the trust. Such a clause gives absolute powers to the trustee, which will result in trust engaging in non-genuine activities. On the above objection, the learned counsel for the SC has rightly submitted that the said clause gives power to the trustee only for the objects of the trust, and at the stage of registration, it cannot be said that there was a possibility of misuse. Tomorrow there may be misuse, that he cannot deny me registration. If tomorrow I am not going to apply it for charitable purposes, he can cancel my registration, or he can deny me the exemption under sections 11 and 12. We are therefore of the view that none of the reasons given for refusing registration of the SSC are acceptable. The objects of the SSC are charitable in nature, being solely for the purpose of education, and all activities spring from and are to be read in conjunction with clause 2b of the deed of trust. Clause 2b is the main object, which we have extracted in the earlier part of this order. There are sufficient safeguards in the Act in the event of the object not being carried out in accordance with the deed of trust, or wherever there is personal benefit. There is nothing brought on record by the CITE to show that the objects of the SSC are not charitable and that its activities are not genuine. In the circumstances, we are of the view that the SSC ought to have been granted registration under 12AA. We direct the registration under 12AA be allowed. Then they have relied on case laws, my lord, in para 11. I'll not trouble your lordships with that. Now, kindly see, my lord, I have created this trust, or this trust has been created for the main object of education. That is forthcoming in clause 2b, which my learned friend has not read. Therefore, I will, if I may request your lordships to kindly take clause 2b, which is at page 24 of that paper book filed before the tribunal. Clause 2 starts at page 23. Mallards have it. Clause 2, then kindly turn over the page. B, clause B. Subject to the provisions of subclause A of clause 2, the trustees shall hold the trust funds upon trust, so that as far as practicable, the corpus shall always remain intact, and only the income thereon shall be used, but with liberty to the trustees at their discretion to use the corpus from time to time, either wholly or in part or parts, on such public educational purposes, including spiritual activities which are beyond any specific religion, research in the region of raising human consciousness, and such practices as to aid such activities, well-being, welfare, recreation, and education of children and adults mentally retarded, normal, invalid, or handicapped, research in the region of collective and community living in harmony, unity, and peace and growth of human consciousness to higher levels of spirituality, any purpose that the law and the provisions of the Income Tax Act 1961 regard as educational purpose, and in such manner as the trustees may think fit, and for one or more of the aforesaid purposes to the exclusion of others as the trustees may think fit, provided that income as well as capital, kindly see, provided that income as well as capital as well as corpus shall be applied only towards educational purposes as aforesaid, and any accumulation of income shall also be applicable to such educational purposes as aforesaid. So the entire object, kindly see one more clause, in the preamble of the agreement itself, page 17. Which my learned friend also read. I'm just drawing, putting further emphasis. Page 17, clause 2, Malad.
17.
Page 17, running page 17, Malad, clause 2. The page number, printed page number on the top right corner. Or internal page number 3 of the touch deed, if Malads have the internal page. Clause 2.
Page
Internal page 3 of the trust deed.
Yes.
Clause 2. In furtherance of desire for advancement of educational objects or purposes has intended to create a trust called so and so as a central institution for carrying out public educational object and purposes wide enough for the extension of the benefit thereof to all irrespective of class, community, creed or religion. Then kindly see how clause 3 also, which is what the department is relying on, has been worded. Clause 3, which is at internal page 9 of the trust deed. My lords, have clause 3, internal page 9.
Yes.
Without prejudice to the generality of the foregoing objects, that is clause 2b, or purposes, and without limiting the scope of the trust, which is to carry out any activity for the purpose of education, but subject as aforesaid, it is declared that the trustee shall each year apply the income of the trust fund and may at their discretion at any time and from time to time apply also trust fund or parts of the trust fund in and towards any one or more of the following specific educational objects or purposes to the exclusion of others and others of them in such proportion and manner in all respects as the trustees may in their absolute discretion think proper, that is to say. Now this is where, my lord, the commissioner takes the township out of context and reads. He doesn't read the entire clause. First of all, the preamble itself says this is to further the main object under clause 2b. Now kindly see 3.1 also. To establish, erect, equip, and maintain or contribute or aid towards establishment, erection, construction, maintenance of research centers and or spiritual centers, bodies and establishments, townships, halls, and housings needed for such pursuits, to assist activities such as farms, workshops, schools, meditation halls, reading rooms, libraries, homes, gardenings, furnishing, to provide for physical and other needs as such. Clause 2 also says the same thing. My lord, I am not building townships, or the object is not to build townships for selling them commercially. The objective for building the township is perhaps to build a university. We don't know. Tomorrow, after I have enough funds, I may build if my school or the college or the educational institution I set up, if it grows big, I may have to have a township as well to accommodate the teachers or the lecturers and the staff and all that. So it is only for that purpose. It cannot be read out of context. And more importantly, my lords, this trust deed was signed in February 2018 and the registration was applied for in March 2018. I have not even started the activities. So the question of going into genuineness of the trust, only when I start my activities and if I'm not utilizing the funds for charitable purposes, then the commissioner will have some material to say that I'm not entitled for registration. So therefore, my lords, and in any event, one is the trust deed is very clear. One more important clause, my lord. I'm sorry, my lord. Page 33, clause 8. Which my learned friend didn't point out, therefore I'm just pointing out. Page 33, clause 8, or internal page 16 of the trust deed.
Yes.
The trust property or any part thereof shall not be applied for any of the purposes mentioned in this deed, which are not or cease to be educational objects and purpose, but only to such objects and purpose as may be educational objects or purposes in law, and such other objects and purposes of educational nature as the trustees may think fit. There's a prohibition for me to use the funds or the property of the trust for anything other than education. So even if I build townships tomorrow, I have to use it for educational purposes.
Yes.
Therefore, one is my first submission would be basis the various clauses in the trust deed which the tribunal has also examined, that the tribunal has given a fact finding that the main object of the trust is education. All the other objects which the commissioner has relied upon are only incidental objects, and that does not allow him to deny registration. And that fact finding has not been questioned or demonstrated to be perverse by the department. So on that ground itself, the appeal should be dismissed at the first instance. My second submission, my lord, is the commissioner, in a case where the object of the trust is education, or say relief for the poor, or any of the other objects specified in 215, cannot even go into the issue of commercial nature, because if my lords kindly see section 215, trade, commerce and industry is prohibited only in respect of general object, not in specific object where it is education and the relief for the poor and etc. etc. If my lords kindly see section 215 for a moment. Section 2, subsection 15, my lord. Charitable purpose includes relief of the poor, education, yoga, medical relief, preservation of environment, so and so, and preservation monuments or places or objects of artistic or holy historic interest, and the advancement of any other object of general public utility, provided that the advancement of any other object of general public utility shall not be charitable if it involves a trade. So the restriction as far as trade, commerce or business is only restricted to advancement of any other object of general public utility, not if my object is relief of the poor, education, yoga, medical relief. So that's the difference, and that difference has been noticed by the courts. I'll take your lordships to that the judgments also. The restriction, if at all, in the proviso that is there for trade, commerce or business will apply only to the last leg of that charitable purpose definition, that is the advancement of any other object of general public utility and not to others.
Yes.
There also, if your lordships kindly see, even in the proviso, it says, unless such activity is undertaken in the course of actual carrying on or carrying out of such advancement of any other object of general public utility. So even if it is, the trust is established for any other object of general public utility, if the trade, commerce or business is incidental to the main object, it will still be allowed as treated as a charitable purpose. But in the cases of relief for poor, education, yoga and others, you cannot even go into that.
Yes, yes, got it. Yes.
The reason is this, my lord. A charitable institution cannot sustain itself only on donations. They will have to have some activity which generates revenue, which will be plowed back into charitable activities. So that is the object, my lord. Now kindly see, my lord, I'm relying on a few case laws. Now the judgment which my learned friend cited, my lord, with great respect, that the sole trustee Lok Shikshana Trust, the Honorable Supreme Court judgment of I think 1975 or something, that is no longer good law. Subsequently, a constitution bench of the Honorable Supreme Court considered this judgment, and so much so, my lord, they have said that it's no longer good law, because if my lords kindly see the judgment at page 25, it's a decision by 3 honorable judges of the Supreme Court, and Justice Beg dissented, and Justice Khanna and Gupta, Justice H.R. Khanna and Gupta have given the majority judgment. Now, in a subsequent constitution bench judgment, my lord, the Honorable Supreme Court agreed with Justice Beg.
What is the citation?
My lord?
Which page?
Yes, in Surat Art Silk Cloth Manufacturers, page 7, the judgment starts at page 7. And if my lords kindly come to para 6 first. I'll point out later, my lord, how they dealt with the judgment relied upon by my learned friend. My lord, before I take your lordship through para 6 at page 15, I'll just read the question for reference before the Honorable Supreme Court, which is at para 1 at page 12. Running page 12, para 1.
Wherein the Act says, my lord, the charitable purpose means it includes, not means and include.
May I read para 1, my lord? I'm not sure. I think somebody else is.
Yes, para 1.
Para 1.
Wording, my lord, is very clear. Since this is a case, my lord, we should not to.
These tax references have been made by the tribunal directly to this court under section 257 of the Income Tax Act 1961. Since there is a conflict of opinion amongst different high courts as to the interpretation of the words not involving the carrying on of any activity for profit. At that point in time, there is the section 215 had these words, which was subsequently excluded in 1983, and this proviso was reinserted in 1989 or so. So this is what was for consideration before the Honorable Supreme Court, occurring at the end of the definition of charitable purpose in clause 15 of section 2. Originally, these references came up before a bench of 3 judges, but having regard to the great importance of the question involved and the serious repercussions which an adverse decision, I'll skip that, my lord. Kindly come to para 6 at page 15. But even if such a contention were permissible, my lords have that, we do not think there is any substance in it. The law is well settled that if there are several objects of a trust or institution, some of which are charitable and some non-charitable, and the trustees or the managers in their discretion are to apply the income or property to any of these objects, those objects, the trust or institution would not be liable to be regarded as charitable, and no part of its income would be exempt from tax. In other words, where the main or primary objects are distributed, if the main or primary objects are distributed, each and every one of the objects must be charitable in order that the trust or institution might be upheld as valid charity. But if the primary or dominant purpose, this is what I am relying on. If the primary or dominant purpose of a trust or institution is charitable, another object which by itself may not be charitable, but which is merely ancillary or incidental to the primary or dominant purpose would not prevent the trust or institution from being a valid charity. The test which has therefore to be applied is whether the object which is said to be non-charitable is a main or primary object of the trust or institution, or it is ancillary or incidental to the dominant or primary object which is charitable. I'll stop there, Manoj. I'll not read that. So the Honorable Supreme Court says what has to be seen is the main object. If the main object is charitable, all other incidental objects are only for the furtherance of the main object. This thing. Then kindly see para 8, a few sentences in para 8. But the question still remains whether this primary purpose of the SSE, namely to promote commerce and trade in art, silk yarn, raw silk, cotton, art silk cloth, and cotton cloth, could be said to be not involving carrying on any activity of profit. This question arises on the terms of section 215, which gives an inclusive definition of charitable purpose. It provides that charitable purpose includes relief of the poor, education, medical relief, and the advancement of any other object of general public utility, not involving the carrying on of any activity for profit. It is now well settled as a result of the decision of this court in so-and-so that the words not involving the carrying on of any activity for profit qualify or govern only the last head of the charitable purpose and not the earlier 3 heads. That is what I was submitting. Where, therefore, the purpose of a trust or institution is relief of the poor, education, or medical relief, the requirement of the definition of charitable purpose would be fully satisfied even if an activity of or profit is carried on in the course of actual carrying on of the primary purpose of the trust or institution.
Yes.
But then I'll just point out those paragraphs. Para 10 for a moment, Manoj. Page 19. It is clear on a plain natural construction of the language used by the legislature that the 10 crucial words not involving carrying on of any activity of profit go with the object of general public utility and not with advancement. It is the object of general public utility which must not involve the carrying on of so and so, which is what they have said in para. Kindly see para 11 also, fourth line from the top. If the contention put forward on behalf of the revenue were accepted, then as already pointed out above, no trust or institution whose purpose is promotion of an object of general public would be able to carry on any business, even though such business is held under trust or legal obligation to apply its income wholly to the charitable purpose or is carried on by the trust or institution. Manoj, if then what I was saying is a trust, a charitable trust cannot always rely on donations. They have to do some activity to generate other revenue to plow it back into charitable purposes. Therefore, Mallards, we see all the religious institutions also will have a Kalyan Mandap, or a college educational institution will have some activity which may appear to be commercial purpose, but ultimately the proceeds again go back into education itself. Then Mallards, just to point out where, if Mallards kindly see para 22, page 22, I'm sorry. Page 22 in para 14, just on above para 15. The last 3 lines. We may point out that even in sole trustee, a decision which, as we shall presently point out, does not command itself on us to us on another point, the same interpretation has been accepted by this court. Then, my lord, they have dealt with that judgment in para 17, just on top of page para 18 at page 24. A few lines on top of, we therefore agree with Beg J. Lords have that? End of para 17, not about 7-8 lines on top. We therefore agree with Beg J when he said in sole trustee that if the profits must necessarily feed a charitable purpose under the terms of the trust, the mere fact that the activities of the trust yield profit will not alter the charitable character of the trust. The test now is more clearly than in the past the genuineness of the purpose tested by the obligation created to spend the money exclusively or essentially on charity. The learned judge also added the restrictive condition that the purpose should not involve the carrying on of any activity or profit would be satisfied if profit making is not the real object. Therefore, my lord, they agreed with Justice Beg, who was in minority in the earlier edition, and my lord, and also, my lord, the Dharmadipit, which is the subsequent judgment of the Supreme Court, this thing, there they said the profit making will apply only to the general object, not to education. Therefore, my lord, on both these counts, the judgment relied upon my learned friend has no application. Then another judgment of the Honorable Supreme Court, my lord, which my friend also read. I will read it from my compilation, that Ananda Social, page 43. This is where again, my lord, the Honorable Supreme Court says that when the commissioner is considering an application for registration of a newly incorporated trust, he cannot go into the genuineness because the activities have not even started. Kindly see page 46, my lord, para 7. My lords have it?
Yes.
In the present case, the trust was formed on a society on 30/5/2008 and it applied for registration on 10/7/2008 within a period of about 2 months. I applied within 1 month. No activities had been undertaken by the respondent trust before the application was made. the commissioner rejected the application on the sole ground that since no activities have been undertaken by the trust, it was not possible to register it, presumably because it was not possible to be satisfied about whether the activities of the trust are genuine. The Income Tax Appellate Tribunal reversed the orders of the commissioner. The Revenue Department approached the High Court by way of filing an appeal. The High Court upheld the order of the tribunal and came to the conclusion that in the case of a newly registered trust, even though there was no activities, it was possible to consider whether the trust can be registered under 12AA. This judgment is assailed before us. Then para 9 is what my learned friend read from his compilation. Section 12AA undoubtedly requires the commissioner to satisfy himself about the objects of the trust or institution and genuineness of its activities and grant a registration only if he is so satisfied. The said section requires the commissioner to be so satisfied in order to ensure that the object of the trust and its activities are charitable, since the consequence of such registration is that the trust is entitled to claim benefits under sections 11 and 12 of the Act. In other words, if it appears that the objects of the trust and its activities are not genuine, that is to say not charitable, the commissioner is entitled to refuse and in fact bound to refuse such registration. It was argued before us that the commissioner is required to be satisfied about two things. Firstly, that the objects of the trust, and secondly, that its activities are genuine. If there have been no activities undertaken by the trust, then the commissioner cannot assess whether such activities are genuine, and therefore the commissioner is bound to refuse the registration of such a trust. This is the argument put forth by the Revenue before the Honorable Supreme Court. Now kindly see what the Honorable Supreme Court says. We have given our anxious consideration.
We'll continue after the break.
Very well.
How much?
Just 5-10 minutes more, Mother. That's all.
Okay.
Yes.
What up, sir? What up, sir? What up, sir? What up, sir? Sir? Sir?
ಸರ್ ಹೇಳಿ ಸರ್
56 ಇದೆಯಾ ಮೇಡಮ್?
56 ಇದೆ ಸರ್.
ಅಡ್ಜರ್ನ್ಮೆಂಟ್ ಮೆನ್ಷನ್ ಮಾಡಬಹುದಾ 230 ಗೆ?
ಅದು ರೀಚ್ ಆದಾಗ ಮೆನ್ಷನ್ ಮಾಡಿ ಸರ್.
ಓಕೆ.
ಕೋರ್ಟ್ ಆಫೀಸರ್ ಸರ್, ಕೋರ್ಟ್ ಆಫೀಸರ್.
Yes, sir.
ಮೇಡಮ್, ಇದು ಬೆಳಿಗ್ಗೆ ಒಂದು ರಿಟ್ ಪಿಟಿಷನ್ FR ನಂಬರ್ ಮೆನ್ಷನ್ ಮಾಡಿದ್ವಿ, ಟು ಬಿ ಟೇಕನ್ ಅಪ್ ಎಂಡ್ ಆಫ್ ದ ಲಿಸ್ಟ್. ಮನಮೋಹನ್ ಪಿ ಅವ್ರು ಮೆನ್ಷನ್ ಮಾಡಿದ್ರು. ಅದು ಫೈಲ್ ಬಂದಿದೆಯಾ ಅಂತ ಕೇಳಬೇಕಿತ್ತು.
ಫೈಲ್ ಇನ್ನ ಬಂದಿಲ್ಲ, ಬಟ್ ಲಿಸ್ಟ್ ಮಾಡಕ್ ಹೇಳಿದಾರೆ ಸರ್. ಬರುತ್ತೆ ಅದು.
ಡೇ ಬಿಫೋರ್ ಎಸ್ಟರ್ಡೇ ಫೈಲ್ ಮಾಡಿದೀವಿ ಅಂದ್ರಲ್ಲ ಸರ್.
ಹೌದು ಸರ್, 25th ಫೈಲ್ ಮಾಡಿರೋದು ಸರ್.
ಅಲ್ಲ, ಮತ್ತೆ ಇವತ್ತು ಬೆಳಿಗ್ಗೆ ಫೈಲ್ ಮಾಡಿದ್ರು ಅಂತ ನೀವೇ ಹೇಳ್ತಿದ್ದೀರಾ.
ಅಲ್ಲ, ಬೆಳಿಗ್ಗೆ ಮೆನ್ಷನ್ ಮಾಡಿದ್ವಿ ಸರ್.
ಬೆಳಿಗ್ಗೆ ಫೈಲ್ ಆಗಿದ್ದಂತಲ್ಲ ಸರ್ ಅದು.
ಇವಾಗ ಬರತ್ತಾ ಇವಾಗ?
ಅಲ್ಲ, ಬರುತ್ತೆ. ರಾಂಗ್ ಮೆನ್ಷನಿಂಗ್ ಎಲ್ಲ ಮಾಡಬೇಡಿ, ಯಾಕಂದ್ರೆ ಇವತ್ತು ಮಾಡಿದ್ರೆ ಇವತ್ತು ಮಾಡ್ತಿದೀವಿ ಅಂತಾನೆ ಹೇಳಿ.
ಇಲ್ಲ, 25th ಇಮೇಲ್ ನಲ್ಲಿ ಫೈಲ್ ಮಾಡಿರೋದು 7 o'clock ಈವ್ನಿಂಗ್.
ಅಲ್ಲ, ಆಫ್ಟರ್ 4:30 ಎಲ್ಲ ಆದ್ಮೇಲೆ, ಆಫೀಸ್ ಅವರ್ಸ್ ಆದ್ಮೇಲೆ ಮೋಸ್ಟ್ಲಿ ಅದು ಸ್ಟೇಟ್ ಆಗಿ ಮಾಡ್ತಿದ್ದ, ಅದಕ್ಕೆ ಅದು ಇವತ್ತಿಗೆ.
ಆಯ್ತು ಸರ್, ನಾನು ರಿಜಿಸ್ಟ್ರಾರ್ ಹತ್ರ ಮಾತಾಡಿದ್ದೀನಿ, ಅದು ರಿಜಿಸ್ಟ್ರಾರ್ ಆಫೀಸಿಗೆ ಮಾತಾಡಿದ್ದೀನಿ, ಅವ್ರು ಕಳಿಸ್ತೀನಿ ಅಂತ ಹೇಳಿದ್ರು ಫೈಲ್.
ಮಧ್ಯಾಹ್ನ ಬರ್ತೀವಿ.
ಓಕೆ.